Court does call the case of fixing housing 401k versus Erica and Aaron Ward in regards to the bench warrant issue. This is a matter involving Donna Tope. Ms. Tope, state your name.
Donna Tope, I'm appearing on behalf of myself.
All right, Ms. Tope, I had issued a bench warrant for your arrest for failure to appear at a show cause hearing, which I know that you had notice of. You filed a motion in this case to remove and expunge the court's order for contempt and the warrant for your arrest. That is your motion before the court today.
Yes.
Go ahead.
So I would like to put this on the record for my own purposes and also for YouTube.
Right away, the stakes are personal. This is a routine scheduling issue. The judge is confronting a bench warrant tied to a missed show cause hearing, which means a court believer absence may itself be contempt.
The YouTube that was recorded when you issued this bench warrant has been used against me in my professional capacity and for other cases. And therefore, I would like to have this on the record.
Have what on the record?
What I'm going to tell you now in my defense.
Go ahead.
Okay. It's my motion. The following enumerated facts support my motion to remove and expunge from every record, including the YouTube video: A, your order for contempt, your warrant issued for my arrest, and your order to hold me under arrest on $10,000 cash bail. I received the judge's final docket for hearings set for Tuesday, February 3rd, 2026 at my email address on Monday, February 2nd from Ms. Weedling.
Here comes a defense theory, not defiance, but defective notice. In contempt proceedings, service rules matter a lot. Because if notice was legally insufficient, the entire warrant starts to look vulnerable.
I opened the email the morning of Tuesday, February 3rd, because I am a party in a completely different case before this court, and I looked for something on that case on the docket. To my surprise, the docket for 2 p.m. that very afternoon had me listed for a show cause hearing on a case for which I am neither a party nor an attorney. Not having had any notice of appearance for this hearing, I was not able to get to the court in time. So I sent Ms. Weedling the email, which I attached on my motion as Exhibit A, explaining that to the court. I receive all of my business mail at Post Office Box 1283 in Ann Arbor, Michigan, 48106. I check my mailbox weekdays after 5 p.m. On Thursday, February 5th, 2 days after the unnoticed show cause hearing on the court's February 3rd docket, I sent Ms. Weedling the email and photos provided at Exhibit B. The email describes what I received that morning, Thursday, February 5th, 2026, in my post office box, 2 days after the hearing was held. The photos included with my email to the court are of a motion, affidavit, and order to show cause signed by Judge Simpson, along with the postmarked envelope they were mailed in. Exhibit C is hard copies of those legal papers and the envelope. The motion at number 2, page 1, states, I am being held by the judge in contempt for filing a pleading without my client's knowledge, nor being the attorney of record. At number 3.
This is a turning point in our argument. The court's own order demanded 14 days, notice by mail, but the envelope timing appears to tell a very different story. If that timeline holds, the credibility battle just shifted.
On page 1, Judge Simpson requests an order to show cause why I should not be found in civil contempt of court. Can you attach it for me? Thank you. At item 5, page 2, I am ordered to appear before the court on February 3rd at 2 p.m. At 7 on page 2 of the order to show cause, it states that a copy of this order must be served by mail on the person ordered to appear, which is me, at least 14 days before the hearing, which had been set for a hearing on the docket for February 3rd at 2 p.m. The judge's signature is dated January 20th. The envelope is postmarked January 28th. The date the post office mailed it, which is only 6 days before the hearing date of February 3rd, which is not the quote, service by mail within 14 days required by the judge's signed order. I received the order at my address on February 5th, 2 days after the hearing was held, and only 8 days after it was mailed.
And just like that, the judge shuts the door on the notice argument, for now. Notice the confidence here. The court is standing by the original record, which turns this from a paperwork dispute into a direct credibility clash.
Noticed of the hearing at which Judge Simpson found me in contempt for not appearing. The further facts are that in finding me in contempt for not appearing, Judge Simpson issued a warrant for my arrest and demanded an excessively punitive cash bail of $10,000, or so I was told by a person who was in the courtroom when Judge Simpson put his order for my arrest on the record. Based on what I have provided, the judge's motion and order and the mailing envelope, I am asking for the following relief from Judge Simpson. Please retract, remove, and/or expunge all records of the order for contempt, the bench warrant, and cash bail issued by the judge, so that there is no evidence out on the web that the judge issued the order, the warrant, and the excessively punitive bail. I include court records, transcript records, and the YouTube video of the judge's orders that another attorney alerted me to in cases that I am appearing in 3 other circuit courts, and reissue with proper notice to me the show cause hearing the judge wishes to impose upon me. I am perfectly happy and willing to appear at a show cause hearing if I have proper notice. I did not.
This is your proper notice. You had notice.
This explanation is huge. The $10,000 cash bond wasn't framed as punishment for missing court alone. It was tied to the judge's view of the financial fallout allegedly caused by prior filings and delays.
I will stand on the record that I made that day that you had notice of that hearing and that you failed to appear.
And
my staff indicated that. You can argue with me all you want, Ms. Toad. What I will do, though, because you have part of the reason that the bond is set in the amount that it was, is because you had basically been removed from the case, this case. You had filed a pleading, you signed it. Your former client had no knowledge of it.
that is not,
Was delayed.
not correct.
You want to know what? Do not interrupt me, because then there's going to be a whole other problem. Your client stated on the record they did not have no knowledge of it. Defense counsel or plaintiff's counsel had to respond. The amount of the bond is the amount of billings that the plaintiff had incurred based upon you filing pleadings when you weren't supposed to.
Major procedural twist. The warrant gets canceled, but the controversy survives. The judge resets the show cause hearing, which means this isn't over. It's simply moving into the phase where witnesses, evidence, and credibility will decide everything.
And the delay that you caused. It was set in that amount. What I will do is I will cancel the bench warrant. I will reset your show cause hearing. So here's your notice for April 14, 2026, 9 a.m. Thank you. Have all your witnesses, and if you wish to be represented by counsel, you need to have counsel present at that proceeding.
Thank you.
Are you understood? Am I understood?
Clearly.
Thank you. Well, that was fun.